Thank you, Mr. Chairman. Justice Larson, I wanted to just ask you, if I could, two questions about habeas and about right to privacy and some of your writings on it so I can better understand your views. In a 2004 article you wrote, and I think I'm quoting here, it'd be an understatement in the extreme to call the Supreme Court's decision in Lawrence v. Texas revolutionary. The court, overruling a precedent only 17 years old, held the Constitution forbids states from criminalizing homosexual sodomy, close quote. Do you believe the court was wrong to overrule the Texas law at issue in Lawrence, which made same-sex intimacy a crime? And in your view, does the Due Process Clause of the 14th Amendment contain a right to privacy?
Thank you for the question, Senator Coons. As to the first, I would say two things. One, that law review article expressly declined to take a view on the merits. That was the opening paragraph, just to describe here's what they did. And then the next paragraph begins by saying, the merits aside, and then went on for 100 pages to talk about not the merits of Lawrence versus Texas. So that would be the first thing. The second thing I would say was, with respect to any precedent of the U.S. Supreme Court, I think it has been the position of nominees appearing before this body not to take a position on whether they were rightly or wrongly decided. And that is because all circuit court nominees, and in my current position as a justice of the Michigan Supreme Court, are bound by the Supreme Court's pronouncements. And I would never want a litigant in my court, in my current court, even to think that I might not fairly follow the precedents of the U.S. Supreme Court, because I absolutely will. Your second question, I think, was, is there a right to privacy in the Constitution?
Is there a right to privacy embedded? Is the substantive due process analysis that has led to the establishment in a series of affirmed Supreme Court opinions correct?
Well, again, Senator, I don't think it would be appropriate for me to comment on whether the decisions of the U.S. Supreme Court are right or wrong. But you are absolutely right to note that since Griswold versus Connecticut, the Supreme Court has recognized a right to privacy. That has been more than 40 years. I couldn't tell you the exact date of Griswold. I apologize.
Madam Justice, let me move forward if I could. We have just a few minutes. The other point I was getting to was just that Obergefell and Lawrence move beyond the privacy analysis on which Griswold and Roe rest and inserted a different analysis. But why don't one last question for you, if I might, that I think follows up somewhat on a previous question. You wrote an article commenting on the signing statement that accompanied the Detainee Treatment Act of 2005, which outlawed torture. Help me understand your view about whether it would be legal for the president to violate that act in order to engage in torture in order to protect the nation or pursue a higher calling.
Sure. So that op-ed was not meant to comment on that particular signing statement, but rather to talk about signing statements in general. But as to that particular signing statement or any signing statement, if any case were to come before my court that would present that question, what I would do is I would evaluate that under Justice Jackson's three-part typology in the steel seizure case. Right. And in such a case, we would be in box 3, which is the lowest level, which would say that the president's powers were at his nadir. And I don't believe there is a precedent of the U.S. Supreme Court that says that the president has ever survived a box 3 challenge. So that's how I would evaluate it.
Thank you, Justice. If I might, Professor Barrett, first, thank you for introducing your remarkable family. I, too, at times struggle to raise 3 children effectively and well and faithfully, and that you have handled so admirably a much larger family really moved me. I also have a 16-year-old daughter. Your daughters are remarkably well behaved today, so thank you for being so good while your mom is up here in front of all of us. On habeas corpus, I just want to ask you about a recent piece that you wrote for the National Constitution Center. It stood out to me because habeas rights protect against improper restrictions on liberty and provide access to federal courts. And I think I quote here, you said, because habeas was not a tool for obtaining post-conviction relief at the time the Constitution was ratified, the founding generation could not have understood the clause to protect this use of the writ. Isn't it true that eliminating access to federal habeas for post-conviction relief might block ineffective assistance of counsel claims or claims based on actual innocence, and does that concern you?
Yes, so Senator, you're, I think, referring to a short piece for the National Constitution Society Constitution Project, in which Neil Katyal and I wrote a back and forth, yes, where we identified current issues in the suspension clause and controversies. And the post-conviction portion, as I recall, of that essay was fairly brief, and I think just the point that I was making and that Professor Katyal responded to was just we had devoted the bulk of that essay to focusing on the question of Congress's power to suspend the clause in the context of executive detention.
Right.
And so I simply observed that their core office of the writ, and the Supreme Court has also recognized that the core office of the writ is protection against executive detention, that in the context of post-conviction detention, that the court has suggested that since it's not the core office, that there might be more room to move in the suspension clause, but the court has rejected the possibility so far. I mean, the court's precedent is that Congress cannot fully withdraw that, and that essay was not meant to take on that challenge.
So let me just since I have 1 minute. You've also written that the Supreme Court was wrong in Boumediene when it held Guantanamo detainees must have access to habeas. Have you changed your view? Am I misunderstanding or mischaracterizing your view? And do you think Congress could prevent detainees at Guantanamo from accessing courts, or federal courts, forgive me?
Well, in the portion of that essay where I addressed that question, what I said was that the history of the suspension clause and the precedent, Johnson versus Eisentrager, had cut against the majority's position, that the majority's position was driven by other concerns, prudential concerns. So I did indicate more agreement with the dissent's analysis of that constitutional question than the majority's. I will say that as an academic, analyzing an opinion outside of the process of actually deciding a case and reading the briefs is a far more general enterprise. It's a more of a bird's eye enterprise. And so I couldn't say with respect to that issue or any other that I would decide the case the same way as a judge. The role of an academic is very different.
Thank you. Thank you, Mr. Chairman.